Hi, this is Sakib Rahman from the OrthoClips podcast series, and today I'm with Mark Brengelman, attorney of law, JDMA at Mark Brengelman Attorney at Law PLLC in Frankfort, Kentucky, and we're going to be talking about topics not as scientific as some of other ones, but it's of particular interest to all of you. And the title is going to be Use of Electronic Media in Healthcare, How to Stay Out of Trouble. Thanks, Mr. Brengelman, for coming on the podcast.
You're very welcome. This is Mark Brengelman.
Great. So we'll get right into it. What are some of the common ways that healthcare workers use media that could violate HIPAA? We hear about exercising caution all the time. Where do you see that happening?
Well, Dr. Sakib, appreciate the opportunity to be on your podcast today and to be with all of your listeners, and it's a great opportunity to spread the wealth of information and try to be helpful to medical practitioners. And you ask a very general question that's a good one, is to electronic media in healthcare and how you can stay out of trouble. There are certainly common ways that healthcare workers use that could violate HIPAA, and some of the common ones are as follows. Taking a selfie with the patient, or even in the hallway of a healthcare facility where a patient room number is visible, even when the patient is in the selfie. In fact, if the patient wants you to be in the selfie, they're consenting to it. That is not appropriate even then to post that on the healthcare practitioner's social media. So there's no HIPAA violation by the patient if the patient posts their own picture in the hospital, and they can say as much as they want to, but that is not a reason for you to post it. I've seen even neighbors, friends, and family post their own radiographs and say, my kid broke his arm today on the middle school playground. Look at that fracture. And they post their own radiograph, and that's not a HIPAA violation. May or may not be wise, but it is a HIPAA violation if you comment on it as a healthcare practitioner or you post it somehow even though the patient has already done so. The next big thing that's a problem for healthcare practitioners is identifying patients in any way in social media. And so referring to a patient by first name only isn't enough. Referring to them when your Facebook profile tells you that you're a surgeon at Temple University in the orthopedic department, and you take a picture or a selfie outside a patient's room where the patient's room number is identifiable, someone may be able to trace that back and identify the patient, and that is a social media violation. The examples of that I use in addition are the life in a small town example, which is a particularly good one here in Kentucky, because, for example, a nurse may post something after the emergency department shift is over that says, boy, there was a really bad 3-car accident in the town tonight. That teenage driver should have worn her seatbelt. And in a small town like in Kentucky, there probably was only one 3-car accident in the town that evening. In fact, you hope so. And people will see that on social media and know who that is because everybody knows everybody in a small town. Even if the newspaper reports on it on Monday that there was a 3-car accident, you posting something after your emergency department visit may be enough to identify because the newspaper will name names and could it be traceable back to your post that people would know who that was in the 3-car accident. So my other examples to conclude this question were using unsecured or personal devices to communicate with patients or other healthcare providers. HIPAA requires secure digital communications by email or texting. Also, although it's not a HIPAA violation, using your personal device for business and pleasure, where you might be communicating with individuals about patients and such, and then using it for pleasure. If you lose that device, then that risks privacy and HIPAA violations by the healthcare provider. And then finally, although it's not a HIPAA violation, it's a common violation. violating an employer's human resource or employment policy is something that gets healthcare practitioners in trouble. For example, some healthcare entities have a rule that says you can't post anything about work on your social media. You're certainly not supposed to be talking about it at home with your wife or your husband, but regardless of whether you're potentially violating HIPAA by taking selfies in the hallway or with the patient or commenting on patient cases, there are employers that just have blanket rules that says you're not allowed to post anything about your employment.
A lot of examples that I could easily see people doing and maybe not thinking twice about, or thinking, well, maybe that's possibly a problem, but I think it's probably okay, and getting in trouble. So I think those are great examples. And you mentioned the use of your personal device and mixing it, with work and personal use. So a lot of healthcare facilities will issue devices for use on work-related activities, but there are many people who will kind of opt out of that and continue to use their own device. And I think there are requirements that they have to make sure that device is locked. But when is it okay to use your own personal email, maybe phone numbers when discussing cases? And I say discussing cases, this is a audience that reaches a lot of orthopedic surgeons. So, if you have an interesting or difficult case, or you're crowdsourcing perhaps to find out how would you all treat this, how could you can you use your personal email, text with your phone number, or is that going to be a problem most of the time?
Well, that's a very good question as well, and HIPAA does not distinguish between personal or business devices, and the same rules apply to any kind of communication, no matter how the device is used. It's just a lot easier as a practical matter to separate a business personal device or a business smartphone versus a personal smartphone, and you keep those two separate. But regardless, just remember, everyone out there, email and texting has been around a long time. That has been a common method of communication. And also, you're not talking about HIPAA violations when you talk about communications between the employee and the employer that don't divulge protected health information. So a nurse can use his or her personal device to text or contact the employer to say, it snowed a lot last night here in the Philadelphia area. I'm getting a little late start. My kids are out of school. I am coming in for my shift, but I'll be a little bit late. That does not violate HIPAA or divulge any protected health information. So basically, if you use a personal device, or no matter what kind of device you use, you need to make sure that email is encrypted, that text is encrypted, and I am no computer expert beyond that. But you have to make sure that they meet whatever digital requirements that HIPAA requires. But you mentioned crowdsourcing and brainstorming and consultation with other practitioners, and that certainly could be done without naming patient names or without providing enough information that would be identifiable to a patient. So sending an email or text to your surgeon colleagues just saying, ever had a patient with a compound fracture like this or like that, as opposed to sending a radiograph, because guess what? Radiographs have metadata, and in fact, they may already have on them the name of the patient ID number, the Temple Hospital name on it, and things like that. So it's difficult to redact those, but certainly you can consult with other practitioners in a way that doesn't violate HIPAA, so long as you don't name the patient or any other information that could be identifiable to the patient, and you'd be surprised how easy that is to meet.
So, similar to that, I get asked sometimes that, hey, okay, I'm told I have to use an encrypted method, but iMessage is encrypted, so can I just use my iPhone and use iMessage? Or perhaps you're on a different device and you're using WhatsApp, and that's encrypted. But then we get told sometimes by our health systems, well, we have another system that's encrypted. We use a certain proprietary messaging system in our healthcare system that's neither of those, not iMessage or WhatsApp, and our people tell us, like, this is what you have to use if you're going to discuss patient information in cases. What's the difference? I mean, is it okay to use something like iMessage or WhatsApp because it's encrypted and just discuss a patient case with somebody, or not?
That's a question I don't know a solid answer to. I am not a digital expert on those kinds of specific software and application products. I really have no idea. I would say, though, that it's probably not HIPAA compliant. It may or may not be HIPAA compliant. Generally, when it is marketed specifically as HIPAA compliant, and it is usually commercially available software that you have to pay for and use. So I do know things like the Skype two-way real-time audio-video connection. Skype is not HIPAA compliant. There may be other versions of Skype that you can use and pay for that would be HIPAA compliant, but so far as I know, that is an example of one that is not HIPAA compliant. So iMessage, WhatsApp, Skype, some of those things are very likely not HIPAA compliant. They would be if they were commercially available. Generally, you have to pay for those, and they are clearly marketed as such. So once they meet those standards of HIPAA compliance, if through no fault of your own, somebody hacks into your protected and encrypted email or texting account at Temple University or what have you, you're not liable then for, there's no strict liability for that kind of breach so long as you were doing things and using the appropriate encrypted technology. I do want to reflect just at the end of my response here that in my jurisdiction, for example, in mental health law with psychologists specifically, there are state laws that govern licensed psychologists as healthcare professionals, and they tell you how to practice telehealth and telemedicine and telepsychology. So using encrypted communications, encrypted email, having informed consent, how you store electronic data, who has access to that, how you dispose of computer equipment like your laptop computer or the office photocopier and scanner that's on a 2-year lease and goes back to the factory. Just be aware that in some professions, and again I reference mental health, I know we're talking here mostly to orthopedic surgeons and such, but some professions have specific, although general, standards about how you do things electronically, like engage in telepsychology or telepractice.
Mm-hmm. You know, I think that's going to lead me into my last question, which is, what are some tips coming from you for orthopedic surgeons who want to connect through electronic media with their patients? You know, we kind of already talked about, better ways to connect with other docs, but in terms of being out there on social media, on Twitter, on Instagram, or being able to provide avenues for their patients to contact them, to email them, to post messages, and have kind of a connection with the patients in a sphere that they're already using that remains HIPAA compliant, but still allows the doctors to do that and the patients to sort of have the satisfaction of being able to connect better. What are a few good tips to keep people out of trouble?
Well, some very good tips to help good people and healthcare practitioners stay out of trouble would be to continue to use social media, LinkedIn, Facebook, whatever you do to promote yourself as a healthcare professional, as a business person, those kinds of things like that, but not to mix that with anything directly related to patients. So you don't want to be friends, quote unquote, with your patients on Facebook for various reasons, but one of them is you don't want them to post protected health information or to you to respond to it. So if you use social media, you use them for educational purposes in general, for business purposes in general. You have a LinkedIn account for those purposes in general, and stay away from specific client and patient contact. That being said, there are commercially available software programs for a secure online patient portal where you can provide that to patients and patients can communicate you through encrypted messages. My own specialist, my general practitioner, is an internal medicine physician, a DO, and I've just fairly recently myself gotten signed up with a secure patient portal. It can be a pain to use. Every time you log on, they go through a two-step verification and security where if you've signed up and been approved and your physician knows who you are and you provide an email address, a telephone number, et cetera, every time you log on, you get an encrypted text or something that says, we think you're trying to log on. If it's really you, enter this 4-digit code. So then you have to enter the 4-digit code just to be able to read your email from your doctor that says, thank you very much, Mark. We'll see you next week for your appointment.
Right.
But it's effective.
Yeah.
I mean, it's secure, it's clunky, and patients aren't going to like that because they want to be on Facebook and share their vacation pictures with their families and coworkers and then confirm their appointment next week with their orthopedic surgeon. You got to put that down, log on to the secure patient portal, get a text on your phone that says, we think you're trying to log in, enter this 4-digit code and talk to Dr. Saqib. And that's the way you do it, but it's secure and it's effective.
It's a great idea, and I think we're seeing more and more of that now. And hopefully things will get a little bit more efficient for our patients who want to securely connect, but not spend too much time doing it. I think there was a lot of great stuff there. We are out of time. I think there's any other resources you want to just point out to listeners who want to find more, since we're going to finish up here?
Finishing up now, I want to thank you for the opportunity to be on your podcast. And for employers and healthcare providers, look for human resource policy resources. Even the smallest medical office should have confidentiality statements for their own employees, the receptionist, their secretary, and whomever. And any employer should have a solid, robust human resources policy on the use of social media, the use of personal devices, and such like that. So that would be one thing for employees to know what the ground rules are to maintain confidentiality.
Sounds good. Thanks for providing that. And thanks for speaking with me. I really appreciate it. Again, I was with Mark Brengelman, attorney at law, and we were talking about use of electronic media in healthcare, how to stay out of trouble. Thank you.